Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss the legal victories and challenges to your fundamental freedoms and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, the President and General Counsel of Liberty Counsel, explains the latest legal issues all across this country in the courtrooms of America. Liberty Counsel is winning the battle for your constitutional freedoms.
Tomorrow, I present oral arguments on Obamacare at the Federal Court of Appeals. Hi, I'm Matt Staver, founder and chairman of Liberty Counsel and dean of Liberty University School of Law. Joining me is Matt Barber, associate dean of the law school and vice president of Liberty Counsel Action. Matt, tomorrow in the morning, Eastern Time, 9:30 or so, is when court begins, and I present the arguments on the Obamacare, Liberty University versus Geithner lawsuit. It'll be the first case ever argued at the Federal Court of Appeals anywhere in the country. After our argument is complete, then Virginia will ultimately present its argument on Obamacare on a more narrow issue than what we are discussing in our case. But this case will now go through Federal Court of Appeals. We'll have a ruling on this sometime later this year, and then it's off to the United States Supreme Court. Yeah,
the day is finally approaching, and this is a very important case, the case that we have filed on behalf of Liberty University. This thing has got to be derailed, Matt, as we've talked about over and over again on Faith and Freedom. This Obamacare monstrosity is simply unsustainable, and not to mention that it also happens to be unconstitutional, and you're going to be arguing on a number of points of unconstitutionality. You mentioned that it's broader than the case that Virginia has. They're focusing very narrowly on the individual mandate aspect of you can't really compel people to purchase a good or service, but ours is a little broader than Virginia's case. How is ours broader?
Well, theirs focuses on the individual mandate, the requirement that you must have a certain level of insurance or pay a penalty if you don't have that level of insurance. Constitutionally, they raise the similar arguments to our arguments on that issue, that it exceeds Commerce's authority under the Constitution via the Commerce Clause, the Necessary and Proper Clause, and it's not a taxing and spending issue. We have the individual mandate. We raise some of those same arguments. And then we also have a challenge against the employer mandate, which says that employers of a certain size must provide a certain kind of health care to their individual members, their staff, their employees, or they have to pay a penalty. And if one of those individuals has to go outside of the covered insurance to an exchange to get some kind of subsidy for some kind of medical treatment, then that employer has to pay a penalty, not just for that individual, but for all of its employees. So it's quite a stiff penalty. We challenge both the individual and the employer mandate. And then we raise the constitutional arguments that the Attorney General for Virginia raises, but we also add some additional ones that only we can raise, and that is free exercise of religion violation, Establishment Clause violation, Equal Protection violation, Religious Freedom Restoration Act violation, that this is a violation of those additional laws as well. Not only does Congress not have the authority to pass these mandates, but these mandates are unconstitutional under other affirmative laws and statutes as well.
Matt, in recent decades, the United States Congress more and more has started to invoke the Commerce Clause as kind of a catch-all, really so that the federal government can impose its will on the states, on individuals. Really, the Commerce Clause is being used and abused in such a way that it says the federal government can do anything. I think this is probably the greatest example that we've seen of that Commerce Clause abuse, and the courts are not without precedent in slapping down the federal government for abuse of the Commerce Clause. One case I like to mention from time to time is United States v. Morrison with the Violence Against Women Act of 1994. In that case, the court said that Congress exceeded its congressional power under the Commerce Clause, under Section 5 of the 14th Amendment of the Constitution. What is the Commerce Clause? What is it intended to do? And how does Obamacare abuse the original intent behind the Commerce Clause?
Yeah, in that case, it not only addressed the Commerce Clause in Article 1, but also the Amendment 14th Amendment, Section 5, and exceeded both of those powers. Basically, what we have is for the early history of America, the Commerce Clause was used to prohibit the states, or it was actually a negative power on the federal government. We've only had a couple of cases in the history of America that really has stretched the Commerce Clause, and one was involving an individual that was growing wheat out west. And there was an Agricultural Adjustment Act, and there was a concern for the price of wheat. And so individuals were allowed to grow wheat and then sell it, and then they were allowed to grow some additional wheat for personal consumption. But this individual grew more than what his allotment was and used it for his own use. When he was penalized, it went to the Supreme Court, and the Supreme Court said, well, even though that particular activity itself was not commerce, this individual wasn't taking this additional wheat and selling it across state lines or marketing it across state lines. The whole point of this regulation was to regulate the wheat production and transportation and sale across the country. So consequently, if a lot of different people aggregated together did this, it would affect the price of wheat. That was the furthest stretch to the Commerce Clause, and that's one of the cases that the federal government tries to use. The problem with the Supreme Court is that it's never gone past that long stretch of an imagination to reach the Commerce Clause. Even that case involved economic activity.
Right.
And our case involves neither economics nor activity. If you have someone who says, take the wheat case, I don't want to grow wheat. I don't want to eat wheat. What this case that the government is now bringing is saying, no, you have to grow wheat, and yes, you have to eat the wheat.
And here's how much wheat you have to grow, and here's how much wheat you have to eat.
And this is the kind of brand of wheat you have to actually consume. So, I mean, that really is a big stretch. Even though that one case involving wheat growing was the outer limits of the Commerce Clause reach, the federal government now with Obamacare wants to go way beyond that.
They've gone out into the stratosphere with this.
That's right.
It's so I think clearly we have a very strong case. Liberty Counsel is on track to very potentially, this could be the case that makes it to the Supreme Court. I'd like to see that happen because I happen to believe we have the most comprehensive case and are providing the best arguments on many angles. We've mentioned the Commerce Clause, the religious liberties aspect associated with this. That is just as troubling as the Commerce Clause.
Well, it is a couple of things with regards to that. The Establishment Clause, this particular statute exempts certain recognized religions. Perhaps the Amish might be part of that. Perhaps Christian Scientists might be part of that. But if you're not part of that particular religion, even though you have a religious objection, you're not protected. And, in fact, you're penalized. That is really unprecedented. Now, we do have some of that with regards to Social Security, where the Amish are not required to have Social Security like everyone else. They don't have to pay into it because they don't receive it. But that's a tax that they are getting an exemption from, whereas this is a penalty that you have to actually pay because of your religious belief. And if you don't have that particular religious belief, if you happen to be an Amish, then you're not penalized. If you happen not to be an Amish, you are penalized. That's a big difference. Again, we also have the free exercise of religion. People oppose Obamacare for several reasons, not the least of which that it funds abortion. And the fact is they want to not have government tell them what to do with regards to their health care. They want to manage their own temple as God has required them to do. And so this is a real major burden on their religious free exercise. The interesting thing is that the government never even came back and tried to rebut those arguments. So they're unrebutted arguments, which is if you do any kind of appellate work, you never want to have an argument, no matter how weak or strong you might think it is, go unrebutted. And they didn't have an argument to the contrary on both of these.
Well, I think they're clearly on a weak footing here. The government case. I would ask that people pray for you. This is tomorrow. You're going to be going before the Fourth Circuit Court of Appeals, and you've got your arguments all in line, and you're ready to go. And everyone listening right now, please be sure to pray that ultimately the High Court, the Supreme Court, would do away with this unconstitutional government takeover of health care.
Yes, I really would appreciate your prayers. This case is argued tomorrow, so pray for this case. It's going to be in Richmond, Virginia, at the Federal Court of Appeals in Richmond. After this three-judge panel makes a ruling, then it's from there all the way to the United States Supreme Court. We want to make sure that we set this case up and have a good victory all the way to the very end at the finish line. And thank you for your prayers and for your financial support in standing with us. This case has required an enormous amount of time. It's a very significant case with regards to the future of America and the role of the government in our lives. So give us a call at Liberty Counsel, become a part of this ministry. You can go to our website and make an online credit card contribution right now at Liberty Counsel's website, lc.org. That's lc.org. Or call us at 1-800-671-1776.
You have been listening to Matt Staver of Liberty Counsel. Our hope is to encourage and inspire you to stand up for your faith, family, and freedoms. We can accomplish a lot when we work together. Get informed and get involved today. Sign up for our free monthly newsletter, The Liberator. We will send it out to you free of charge. Stay informed with our Liberty Alert email update. Just click on the website at www.lc.org or call us at 1-800-671-1776. Tune in next time to learn more about your rights right here on Faith and Freedom.